Our next topic, statutory interpretation. Legislation, statute, Parliament makes it, but of course it's for the judges to apply that legislation in the courts. This is an aspect, you remember, of the doctrine of sovereignty of Parliament. They must apply an act of Parliament. They're not allowed to throw it out and say, don't like that one. So all the judges can do then is to interpret the words of Parliament. In order to ascertain the meaning of the words of Parliament, the intention of Parliament, the judges use rules and they use presumptions. It has to be said, so far as your exam is concerned, it is the rules which are of key importance. Not once in the past has the examiner directly examined presumptions, so we'll whiz through those pretty speedily. It's the rules we need to concentrate on. Now, you can see just glancing at your notes that actually there's 4 rules given to you in the notes, 4 main rules. The literal rule, the golden rule, the mischief rule, and the Euisdem Generis rule. But actually, if you know the first 3 well, you can pass with full marks just about any question on statutory interpretation. Regard rule number 4 then as a safety net in case you forget something with the other 3. It's the other 3 which are most important. So rule number 1, the literal rule. It says words must be given their ordinary grammatical meaning, which actually can sometimes mean legal meaning. And what we really mean here is the dictionary meaning. So if the judge doesn't know the meaning of a word, just like you and I, he looks it up in a dictionary. And if the dictionary gives just one meaning, then the judge must use that meaning. And that is so, even though this may lead to what seems to be an unjust result, or one possibly not intended by Parliament. The judges must keep literally to the words of Parliament. They're not allowed to read anything in or change them at all. And quite a good example of this is the case of Fisher and Bell, a case that actually you will come across at a later stage when we're doing the law of contract. As it tells you, there was an Act of Parliament that made it a criminal offence to offer for sale an offensive weapon. What happened was a shopkeeper displayed a flick knife in his shop window, in fact with the price tag attached. Well, the issue is, was he offering to sell it? Well, the answer is literally no. All he was doing was inviting customers to offer to buy it. You'll understand the reasoning behind that more when we do the law of contract. So literally, he was not committing a criminal offence by displaying a flick knife in his shop window, even with a price tag attached. Well, do you think Parliament meant that kind of behaviour to be a criminal offence? Well, the answer is yes, they did. They wanted to outlaw the sale of things like flick knives, them being displayed in shop windows. But they didn't achieve that with the words of the Act of Parliament. Well, by the way, that Act of Parliament has now been changed. It now says it's a criminal offence to offer for sale or display in your window, which of course is what they should have said in the first place. Well, that's the first rule, and it's logical to do that one first because it's normally the one that the judges will turn to first. Let's now look at the next rule, called the golden rule. Before we do this rule, let's look at the background of when it's used. Well, we use it where use of the literal rule gives more than one meaning of a word. And actually, in the English language, many words have more than one meaning, so the golden rule is used really rather a lot. So what does the golden rule say? It says, take the meaning which gives the least absurd result. We'd like to say, take the meaning which gives the most sensible result, but sometimes all meanings are stupid, so we take the least stupid meaning. Quite a good illustrative case on this is the case of Sigsworth. The facts are very short. What happened was that a son murdered his mother. And the question arose is, was he her heir so as to inherit her estate? Now, if you look up the word heir in an ordinary dictionary, you will find amongst several meanings is the word son. We talk about a son being someone's heir. But there is another meaning too. An heir is also defined as the person who should rightfully inherit. Which meaning do you think the courts took here? Son or person who should rightfully inherit? It was the person who should rightfully inherit. And that meant here that this son didn't get the money, because of course it's not right to allow people to murder people and then get their money. So giving in this instance a more sensible result. I haven't written down for you the outcome of this case because I'd just like to remind you of the appendix and index of cases where you've got the cases all written down. Make sure in your own time, whenever you come across a case, that you do read to see what happens. So that's the golden rule. On now to the next rule, the mischief rule, also sometimes called the purposive rule. So when do we use this? Well, it's used where the words are ambiguous or uncertain, and use of the literal rule doesn't appear to give effect to the intentions of Parliament. Sometimes you see Parliament will pass an Act of Parliament to deal with a particular problem, or mischief as we call it. And this rule says, take the meaning which deals with the problem, which deals with the mischief. A very well-known case here is Generis and Scott. There was an Act of Parliament which required animals carried on board ferries to be contained in pens. They weren't allowed to wander free on the deck of the boat. And as it tells you, Scott sent his sheep on a ferry, and Generis, the ferry operator, did not put the sheep in pens. And what happened was that in rough and stormy weather, the sheep were washed overboard and drowned. So, of course, Scott wanted to sue Generis for the loss of his sheep. I'm now bringing up the question, though, on the screen in bits to help you understand this a little bit more. So, just looking at the first part. Had Generis breached the Act? Well, yes, the sheep were not in pens. But that wasn't the question that the judge had to decide. He had to decide, had Generis breached the Act such that Scott could sue for the loss of his sheep? Well, what was the problem the Act was dealing with? Why were the sheep supposed to be in pens? Well, as it tells you at the beginning of the facts, the reason they had to be in pens was to stop the spread of contagious diseases. Animals from different farms had to be in different pens. The purpose of the Act was not to stop sheep being washed overboard. So what happened? The sheep being washed overboard wasn't the problem the Act was trying to deal with. So could Scott sue for the loss of his sheep? And the answer is no. Notice, by the way, if because they weren't in pens they'd caught a contagious disease, then yes, he would have been able to sue, because that's the mischief the Act was dealing with. So those are the three main rules. I'm leaving you yourselves to look at the Euisdem Generis rule, but don't spend a lot of time on it. Let us quickly have a look at the presumptions. A presumption, by the way, is something we assume to be true about an Act of Parliament unless the Act says otherwise. So unless it specifically says differently. If we're looking at them, and I'm just going to, with each of these presumptions, give you a kind of a simple translation. The first one, a presumption against legislation extending beyond the territorial jurisdiction of the UK. UK law only applies to you when you're in the UK, not when you go abroad. That's what that one means. Number two, a presumption that legislation does not have retrospective effect. So when an Act of Parliament is passed, it only applies to things that happen in the future. It's not backdated to things you did last week. Number three, a presumption that legislation does not put the UK in breach of its international obligations. So if, say, there's a treaty that the UK has made with another country, the courts will interpret an Act of Parliament to try and keep to the treaty rather than break the treaty. Number four, presumption that legislation does not result in the exclusion of the jurisdiction of the court. This is a presumption that Acts of Parliament should always allow you to go to court. They shouldn't stop you going to court. Number five, a presumption that legislation does not bind the Crown. In simple terms, it means the Queen is above the law. So let's say she was driving her car along the street at 100 miles an hour. Could she be prosecuted for that? No. She's above the law. Just as well, really, a bit embarrassing to have the Queen in prison, wouldn't it? And then lastly, a presumption that statutes do not alter the common law. So if Parliament wishes to change the common law, then it's actually got to say so. So that then completes, so far, that topic of statutory interpretation. There's another little bit to do with human rights as well.